Hello, my name is Anya Flynn and I'm Director of the Decision Support Service. In the following presentation, I will set out the key reforms introduced by the Assisted Decision Making Capacity Act 2015, including the guiding principles, the new decision support framework and the functions of the Decision Support Service. The Assisted Decision Making Capacity Act was signed into law on the 30th December 2015, so it is fully enacted legislation. And to give it part of its long title, it is an act to provide for the reform of the law relating to persons who require or may require assistance in exercising their decision-making capacity, whether immediately or in the future. The new framework applies to adults over the age of 18 years, and it isn't yet fully commenced. Commencement will happen when the ministers sign statutory instruments to make all of the Act operational. And at the time of this recording, in November 2021, our anticipated go-live is in the middle of 2022. These are some of the key reforms introduced by the Act. It will abolish the current wards of court system for adults under the Lunacy Regulation Ireland Act of 1871. The Act also repeals an even older piece of legislation, the Marriage of Lunatics Act of 1811, and that is effective already, so that wards of court are no longer prohibited from marrying simply because they are wards of court. When the Act commences, under Part 6, all current adult wards of court will have their cases reviewed and will transition out of wardship within 3 years of commencement. We understand there are approximately 2,150 adult wards of court, and that review process will be managed by the Wardship Court and the Office of Wards of Court. The Act introduces a statutory functional test of capacity, so that is a test which is time-specific and issue-specific, and I'll say more about that in a moment. And the Act introduces new statutory guiding principles, a 3-tier framework for support, new tools for advanced planning, and the Act establishes the Decision Support Service. So looking first at that functional assessment of capacity. Section 3 says this: a person's capacity shall be assessed on the basis of his or her ability to understand at the time that a decision is to be made the nature and consequences of the decision in the context of available choices, so time-specific and issue-specific. And we can see how this contrasts with the person of unsound mind approach in wardship. I think it's important to say also that there is no diagnostic criteria or threshold. So the Act has nothing to say about what might be a medical reason for a person's decision-making capacity difficulties. And this can mean that, with limited exceptions, the Act isn't prescriptive about who may assess capacity. A person lacks capacity under the Act if unable to do the following: to understand the information relevant to making a decision, to retain that information for long enough to make a voluntary choice, to weigh up and use the relevant information, and then to communicate a decision, and that means communicate with appropriate assistance if necessary. So a person may require, for example, sign language or assistive technology, and those supports should be made available, and the fact that a person requires those supports isn't indicative of a lack of capacity. And it's important to say also that this functional approach is already the standard in common law. What I mean by that is that the High Court has already set out this test as long ago as 2008. And we see this approach also in various policy documents, including, for example, the HSE National Consent Policy and Irish Medical Council guidelines. A word about some terminology which you will hear us use. And first of all, let's look at the definition of a relevant person. So according to the Act, that is a person whose capacity is in question or may shortly be in question in respect of one or more than one matter. And that really is the person who is at the heart of the Act and at the heart of the Decision Support Service and its functions. You will see in parts B and C of that definition, again, the time-specific and issue-specific approach, recognising that a person may have perfect capacity in respect of one matter and may lack capacity, or their capacity may be in question in respect of other matters. It's no longer a blanket definition. You will hear us use also the term decision supporter, and that isn't a term which you will find in the Act, but we in the DSS have adopted it to mean all of the following categories. You will see the decision-making assistant, DMA, co-decision maker, CDM, decision-making representative or DMR, an attorney appointed under an EPA, which is an enduring power of attorney, and a designated healthcare representative or DHR appointed under an advanced healthcare directive or AHD. So we use the term decision supporter to refer to all of these collectively. These are some of the really important guiding principles introduced by the Act. So we see first of all the presumption of capacity. And like the functional assessment of capacity, this is already the standard at common law. In other words, it's how we should be doing things already. And what the presumption of capacity says is that an adult is presumed to be able to make their own decisions unless and until the contrary is shown. And that means shown in that functional way that we've just looked at. The Act says also that a person must be supported to make their own decisions as far as possible. And you can't conclude that a person lacks capacity to make their own decisions unless you've done everything to support them to arrive at their own decisions independently. An unwise decision doesn't mean that the person lacks capacity, and you might sometimes hear this shortened to the right to be unwise. What the Act is actually saying is that the fact that a person wants to do something that seems objectively risky or unwise doesn't mean that they lack the capacity to decide to do it. It may give rise to concern, it may prompt an assessment of capacity, but it isn't evidence by itself of a lack of capacity. The Act speaks also about the importance of dignity, bodily integrity, privacy, autonomy, and the right to control over one's own financial affairs and property. And really importantly, it says that we must give effect as far as practicable to a person's past and present will and preferences as far as these can be ascertained. And that is really at the heart of the United Nations Convention on the Rights of Persons with Disabilities, which Ireland ratified in spring of 2018. The UN Committee for that convention has been very strong on the importance of will and preferences and a move away from the idea of a best interest standard. At the same time, we should act in good faith and for the benefit of the person. So when we talk about decisions, what do we mean? Well, looking again at the definition section of the Act, section 2, you will see decisions very broadly defined and separated into two categories. So there are property and affairs and personal welfare. And under property and affairs, you will see here matters relating to a person's property, the sale of property, the acquisition of property, carrying on of business, discharging debts and liabilities, providing for other purposes, the conduct of court proceedings, or applications for state benefits. A very broadly defined category. Similarly broad then is the personal welfare category, so that could cover decisions relating to accommodation, education and training, social services, healthcare including medical decision making, and the very broad catch-all other matters relating to the relevant person's well-being. So all of these are the sorts of decisions which are capable of being supported and planned for under the Act. And this is what is really new and ambitious in the 2015 Act. This is the new three-tier framework for supports. So if we look first of all at the lowest and least formal level of support, and that's the decision-making assistant or DMA. So this is a person appointed by the relevant person to help them obtain information relevant to making a decision, to explain that information to them, and then to help the relevant person communicate what they want to do. It's important to say that the relevant person is still making the decision. And this can all be set out then in a decision-making assistance agreement. So it's clear what is in scope or not in scope. There's quite a bit more formality then at the middle tier, the co-decision making agreement. And as the name suggests, this describes a process by which the relevant person can appoint somebody with whom they are going to take specified decisions jointly. There's quite a bit more formality required under the Act. This is an arrangement which is registered with the Decision Support Service, and it must be supported by some items of documentation, including capacity statements from a medical and another healthcare professional. And the Act, I think, has been quite progressive in this regard, in recognising that it may not necessarily be the medical professional who is best placed to supply that statement around the person's capacity. It may be that it is another allied healthcare professional who is in a better position and knows the relevant person better and is best able to speak about their capacity. So that could be, for example, a nursing professional, a speech and language therapist. Regulations will provide for who can provide these statements. At the top tier then, there is still a route to court, and it's now the Circuit Court. The High Court largely it administers the wardship jurisdiction. Under the new Act, an application can be made to the Circuit Court by any person with a bona fide interest in the welfare of the relevant person. The idea of the Circuit Court is that it's regional, accessible, and it's hoped more cost effective. So that person is applying to the Circuit Court for a declaration in relation to the relevant person's capacity in respect of a particular matter or matters. The applicant can in fact be the relevant person himself or herself. The route to court should be very much a last resort, and only after the lower tier supports have been considered and found to be insufficient. Well, if the court declares that the person lacks capacity, then the court can make the decision itself, and the court might do that if it's the least interventionist thing to do and if it's a once-off decision perhaps. Or the court can appoint a decision-making representative to take decisions on behalf of the relevant person. In the next slide, I set out the Part 5 process in a little more detail. So the decision-making representative ideally will be somebody from the person's life, somebody known to them, and again in a pre-existing relationship of trust. But in the event that no such person is available, the court can ask the DSS to nominate a decision-making representative from its panel. These are all arrangements which are supervised by the Decision Support Service, and in respect of the middle and top tier, there are requirements that the co-decision maker and the decision-making representative will file reports with us on a periodic basis. So there's quite a level of regulation involved, and that's all with the idea of supporting the relevant person and ensuring that their rights are upheld. There are also eligibility and suitability criteria, so that, for example, a person with convictions or family court orders against them in relation to the relevant person would not be eligible to step into one of these roles. Also, if the relevant person is in residential services, then the owner or registered provider of those services is not eligible to step into one of these roles. And all of these decision supporters must apply the guiding principles that we've looked at. On this slide, I'm just elaborating a little more on that Part 5 application. So as I mentioned, any person with that bona fide interest in the welfare of the relevant person may make an application to the Circuit Court. The court may order expert reports to make its determination. It may then make that declaration that the relevant person lacks capacity in respect to specified decisions. The court will look at whether mid-tier support, the co-decision maker, will suffice. The court may make a declaration as to the lawfulness of a proposed intervention. It may proceed to make the decision if it's urgent or expedient to do so. It may appoint that decision-making representative, making an order which is limited in time and scope. And in doing all of this, it has to consider the will and preferences of the relevant person. It will look also at existing family relationships, at the complexity of the decisions in question, and the supports which will be available to any proposed decision-making representative. And the court may appoint a decision-making representative, as I've said, from a panel to be maintained by the Decision Support Service. The declaration which the court makes is subject to review and re-entry before the court, and the decision-making representative has reporting duties. Let's look then at advanced planning, and this is why we describe the Act as being an act for everyone, because all of us should think about planning ahead for a time when potentially we may lack our own decision-making capacity in the future, whether as a result of accident or illness. So there are tools in the Act which allow persons to plan ahead while they have capacity and to appoint decision makers for a time when they might lose their capacity in the future. Enduring powers of attorney already exist. They are provided for under the Powers of Attorney Act 1996. So an EPA made under the 1996 Act is still a valid document. If somebody is to make an EPA after commencement of the 2015 Act, then it is a 2015 Act enduring power of attorney. And what is different is that EPAs under the 2015 Act are subject to new reporting requirements and supervision by the Decision Support Service. Again, as with co-decision making agreements, capacity statements are required from medical and another healthcare professional when these enduring powers of attorney are created and registered. And enduring powers of attorney and attorneys appointed under them are subject to new complaints and investigations procedures. In fact, this is where we do have a point of interaction with a 1996 EPA, in that we will now in the DSS be able to investigate complaints about the operation of EPAs under the older Act. And the second important tool for advance planning, and again something that we all should consider, is the Advance Healthcare Directive. These already exist, but the Act puts them on a statutory basis. And the Act restates the fundamental principle that a relevant person who has capacity is entitled to refuse treatment for any reason, notwithstanding that the decision appears to be unwise, not based on sound medical principles, or may result in death. So fundamentally, treatment is predicated on consent. The purpose and content then of an Advanced Healthcare Directive is to ensure that you can continue to ensure that your will and preferences are known should you lose capacity in the future. It provides healthcare professionals with information about treatment choices. In your Advanced Healthcare Directive, you may appoint a designated healthcare representative, or DHR, who can act as your agent, who can ensure that healthcare professionals know about your Advanced Healthcare Directive and respect your wishes. A refusal of treatment contained in an Advanced Healthcare Directive is then as effective as if that refusal of treatment is being made contemporaneously in the present tense by a person with capacity. In your AHD, you may refuse life-sustaining treatment, but the AHD has to be explicit in that regard. And in your AHD, you cannot validly refuse basic care. So what the Act is saying is that you cannot say, if I lose capacity in the future, I do not wish to receive ordinary oral hydration or nutrition, for example, or I do not wish to have warmth or hygiene measures taken. They would not be valid refusals of treatment. The Act distinguishes between requesting treatment and refusing treatment in an Advanced Healthcare Directive, so that a request for treatment is something to be considered, and if it isn't being followed, then reasons why not should be documented, whereas a refusal of treatment is mandatory in effect where this is a valid and applicable Advanced Healthcare Directive. Where there is any doubt about validity and applicability, then there is a role for the court to determine, and that is the High Court when it concerns the refusal of life-sustaining treatment. There are provisions contained in the Act for the protection of healthcare professionals from civil and criminal liability. The existing criminal law in relation to murder, manslaughter, assisted suicide is unaffected. There is one exception contained in the Act, you'll see it at section 85(7), which creates an exception where the directive maker is later detained under the Mental Health Act. So that if a person in their Advanced Healthcare Directive says that they are refusing certain mental health treatments, then that is not considered valid and applicable in the event that they are subsequently detained under the Mental Health Act. Important to say that we anticipate that the Act will be amended in that regard. Let me say something about next of kin, or what we in the Decision Support Service refer to as the myth of next of kin. And this is the incorrect belief that a person's close family relation by virtue of that relationship, already has legal authority as a decision maker. It is often believed that a person's spouse or partner or the parent of an adult child or adult child of a parent is entitled to access information and to give or withhold consent. That isn't correct and never has been correct, so the Act isn't taking anything away in that regard. It is an extensive misapprehension, however, as a survey conducted in 2018 showed. A person's next of kin under this Act, in fact, has an opportunity to step into a formally recognised role with known parameters. And that close family relationship could, in any case, always be important in supplying information about their loved one's will and preferences, beliefs and values, but that's quite different from being a decision maker. Looking then at our service, the Decision Support Service. So we were going to be called the Office of Public Guardian. In an earlier version of the Act, that was the name of the service. And the view was that Decision Support Service more accurately reflected our fundamental purpose and the ethos of the Act, which is to support people as far as possible in making their own decisions. We in the Decision Support Service often say that the brackets around capacity in the title of the Act actually are very telling, because the first step must always be to support people to take their own decisions independently. The functions of the Decision Support Service then include these: to promote awareness and confidence in the new framework and other matters relating to capacity, including the United Nations Convention on the Rights of Persons with Disabilities, to provide information and guidance to organisations and bodies, to maintain searchable registers of arrangements, to supervise these decision support arrangements. We have a complaints and investigations function, and I'll say more about that in a moment. We will support organisational change to promote the exercise of capacity. We maintain certain panels of persons to carry out roles under the Act. We will publish codes of practice, and I'll say more about those also. And we are the central authority for the purposes of the Hague Convention on the International Protection of Adults. Looking at our complaints and investigations function, and this provides important safeguarding measures under the Act. We may take complaints in relation to the following. We could receive a complaint that a decision supporter is acting outside the scope of their particular decision support arrangement, that they are unsuitable in the way that the Act describes, that the particular decision support arrangement is not operating in accordance with the will and preferences of the relevant person, that fraud, coercion or undue influence have been used to compel the person to enter into the arrangement, or there could be complaints relating to the person's capacity, perhaps that the person has capacity and doesn't need the decision support arrangement, or does not have the requisite level of capacity for the arrangement which is in place. The complaint could also relate to a breach of the decision supporter's function or a breach of any of the provisions of the Act, including the guiding principles. In response to such a complaint, the Director may commission a special or general visitor, and they will be panel members under the Act who assist in our supervisory and complaints and investigations functions. We can summons witnesses, take up evidence, and we can escalate a well-founded complaint to court for the court to consider whether the decision supporter should be removed from their role. We expect under amendments to the Act to be given the opportunity to and the power to apply to court to ask the court to temporarily suspend the decision supporter from acting pending the investigation where it seems that there is urgent cause to do so. We may, if necessary, have to escalate a matter for criminal investigation. The Act creates a number of criminal offences, including one of abuse or neglect of the relevant person. We can conduct own initiative investigations, and we also have authority under the Act to resolve complaints on an informal basis. We have found it important or useful to say what is outside of the remit of the Decision Support Service. So the Decision Support Service does not have a function to make decisions for people. In some other jurisdictions, the public guardian is the decision maker of last resort. We don't directly appoint decision supporters for people. We do have that role to nominate decision-making representatives from our panel, who may then be appointed by the court. We will not have a function to manage people's money and property. And we don't regulate and supervise arrangements outside of the Act. Our duty is to regulate and supervise these new arrangements on the framework. It may be opportune to look at how decision making is being managed currently, to consider whether that is being done in a way which is consistent with the Act, to consider whether a person should be supported by one of the new arrangements under the framework. We're also not the regulator of other professionals, so we don't have a disciplinary remit in relation to anyone other than decision supporters working within a decision support arrangement. So there will be a general guidance code on the supporting decision making and assessing capacity. There will also be codes to provide guidance to decision supporters, to our panel members and to professionals, legal professionals, financial services professionals and financial service providers, and health and social care professionals. The status of a code under the Act is this, so that a person concerned shall have regard to a code of practice when performing any function under the Act in respect of which the code provides guidance, and the code can be admissible in relation to other court proceedings, including regulatory proceedings. Consultation at the time when this recording is taking place in November of 2022, consultation on these codes of practice is imminent, and the codes will all be approved by the Minister prior to publication and prior to commencement of the Act. So where are we then currently on the pathway to commencement of the Decision Support Service? We are working to an establishment project plan. That's a time-bound costed plan which is well underway. Our overall establishment programme comprises 25 sub-projects. Thinking then about our design principles and our vision for the service, we see it very much as a person-centred, rights-based service. Our intention is to adopt a digital-first approach, so we are putting in place digital platforms for interaction with the Decision Support Service. We are conscious that those will have to be accessible tools for interaction with the Decision Support Service, and we are engaging in focus group work to ensure that that happens. Ultimately, our vision then is for an outward-facing and accessible service. Our communications and stakeholder engagement is intensive and ongoing and will continue post-commencement. The key milestones between now and commencement we would see as being these. We will be commencing shortly with our panel recruitment. The consultation on the codes of practice will take place in 2 phases. We will be engaged intensively in awareness raising in the months prior to commencement being in the middle of 2022. The Act itself is to undergo some amendment, and that obviously is the responsibility of our parent department, and that is now the Department of Children, Equality, Disability, Integration and Youth. And we think that those amendments actually will usefully bring about change which will make it an Act which better serves the relevant person. And we in the Decision Support Service have been able to make submissions about what we think those amendments should be. Thank you for viewing this presentation. You will find more information elsewhere on our website, including frequently asked questions and guidance on what you can do to prepare for commencement. Thank you.